In 1983, BMW adopted a nationwide policy regarding cars that suffered damage before arriving at a dealership. If repairing the damage cost under 3% of the car's retail value, the car would be repaired and then delivered to the dealer to be sold as new. Then one buyer discovered that his perfect new Beemer was actually damaged goods and sought revenge in BMW of North America versus Gore. In 1990, Ira Gore paid a Birmingham, Alabama dealer $40,000 for a new black BMW. For 9 months, he was perfectly happy. Then he decided the car could look a little snazzier. He took the Beemer to a car detailer called Slick Finish. Mr. Slick told Gore the car had already been repainted. Gore could no longer delight in his vehicle. Convinced he'd been cheated, Gore sued BMW of North America in Alabama State Court. He alleged that BMW's failure to disclose the car's repainting was suppression of a material fact. Gore's car had indeed been repainted at a cost of about $600, or 1.5% of its retail price. Gore's expert said the car was worth 10% less than a car that hadn't been repainted, making his actual damages about $4,000. Gore asked the court for punitive damages to persuade BMW to change its nationwide policy. BMW had sold nearly 1,000 repainted cars as new. The jury determined that BMW's non-disclosure constituted gross fraud nationwide and imposed punitive damages of $4 million. The Alabama Supreme Court held that the award should be based solely on BMW's conduct within Alabama and reduced the punitive damages to $2 million. The United States Supreme Court granted cert.